Burden of proof, differences between civil disputes and criminal law. Introduction. Criminal and civil conflicts are separate legal disciplines with goals, proof standards, and defenses. Civil disputes are conflicts between private parties seeking restitution or settlement for monetary or personal injury to return the affected party to their previous status. For offenses against society, criminal law focuses heavily on punishment and rehabilitation. While the goal of a civil dispute is restoring the injured party's initial state, in criminal law, the aim is punishment and rehabilitation. Civil dispute versus criminal law. Criminal law and civil dispute are two different branches of the law. A civil dispute involves an argument between private individuals or groups and the demand for payment for property damage or bodily harm. The goal is to put the aggrieved party in the same state as before, and the burden of proof is sometimes reduced to requiring only a majority of the evidence. The government enforces criminal laws that pertain to crimes against society. It discusses behaviors that are seen as criminal, including robbery or violence, and places a strong emphasis on punishment and rehabilitation. Greater proof is required, and it must be shown beyond a reasonable doubt. Usually, the burden of proof necessary to win a case in court is determined using the majority of the evidence. Because of this, the party making a claim ought to have adequate proof to persuade the court that their account of the events is more likely than not true. In contrast to criminal proceedings, the bar is lower when proof beyond a reasonable doubt is necessary. It can be used to prove a position in a civil dispute through documents, testimony, and expert opinions. Criminal proceedings must meet a significantly higher level of proof than civil ones, where the burden of proof is substantially lower. The prosecution is responsible for establishing the defendant's guilt beyond a reasonable doubt. For the jury and judge to be satisfied beyond a reasonable doubt that the defendant committed the crime, the evidence must be compelling and persuasive. To prove the elements of the crime and the defendant's guilt, the prosecution must provide evidence, including witness testimony, tangible evidence, and expert opinions. The defendant is entitled to an acquittal if the prosecution is unable to reach this high standard. Defense. Defendants in civil disputes may assert a variety of defenses to contest the allegations brought against them. Lack of evidence is a frequent defense in which the defendant claims that the plaintiff has not shown enough proof to back up their allegation. The statute of limitations contends that the plaintiff's claim is barred because too much time has elapsed since the claimed occurrence, which is another line of defense. A distinct defense is contributory negligence, in which the defendant argues that the plaintiff's negligence or acts were to blame for the harm they sustained. It is also possible to apply the consent defense, which exonerates the defendant by arguing that the plaintiff voluntarily consented to the risks or behaviors involved. Defendants have a variety of defenses available to them in criminal law proceedings to refute the prosecution's case. When defendants argue that their acts were necessary to defend themselves or others from harmful circumstances, they frequently raise the argument of self-defense. If the defendant argues that they were mentally unable to comprehend the nature and effects of their acts at the time of the offense, the insanity defense may be invoked. This defense, known as an alibi, disavows the defendant's involvement in the crime by showing that they were at a different location when the criminal activity was committed. The final avenue of defense is called duress, which claims that the defendant was coerced into doing the crime under the threat of significant harm or death. Examples. Regarding civil disputes, the first example is the absence of evidence, where the defense argues that there is little evidence to support the plaintiff's allegation. Second is the statute of limitations, which, according to the defense, is untimely because the plaintiff's claim was submitted after the deadline. Third is contributory negligence, as, according to the defendant, the plaintiff's conduct or carelessness contributed to the damage they sustained. When it comes to criminal law, the first example is self-defense, as the accused claims that their actions were required to defend either themselves or others from harm. The second is legal insanity, which, according to the defendant, means they were legally crazy at the time of the offense and lacked the mental capacity to comprehend what they were doing. Third is an alibi, a statement made by the accused to show they were somewhere else when the alleged crime was committed, proving their innocence. Conclusion. it is necessary to stress the distinction between criminal and civil law. Criminal law deals with crimes against society and aims to punish and rehabilitate criminals. In contrast, civil disputes concentrate on private conflicts and seek to compensate for financial or personal loss. In contrast to criminal law, which demands proof beyond a reasonable doubt, the burden of proof in civil cases is less onerous and simply requires a majority of the evidence,